Principal seat matter, appeal hearing, item number 1.
Made is a lordship.
Yes. Yes, yes. Yes.
Lordship, may I pray that this case may be fixed on Monday for lordship, as lordship your will be available in the principal seat
Yes,
from
can,
next week.
can be fixed.
Fixed on Monday, lordship.
Yes, can be fixed. Item number.
Item number one, only one item. Otherwise, scan copy is available, and this is very premature. Only
No, whatever we have a number of grounds ready with us. So it needs a length of hearing, lordship. So let it be on Monday, lordship,
Okay.
and the physical court.
okay.
As requested by learned counsel Ms. T. Som for the petitioner, list this matter on Monday. What is the date?
24th.
24.
List this matter on 24th. Yes.
I'm
Problem.
declared.
May I please, Lordship?
Hmm.
My Lord, I mentioned item number 13 on behalf of S. Mary, my Lord. My Lord, I am informed that she is yet to receive instruction. So, praise for 3 weeks time, my Lord. Item number 13.
Okay. On behalf of
S. Mary.
S. Mary, okay.
Yes. Senior
Learned-
government advocate.
Huh, sorry?
Senior government advocate. S. Mary.
Senior governor. You are PP, no?
Yes, ma'am.
Learned PP.
Tip of home.
It,
Tip of home.
লিখে দিবেন নাম বলে। On behalf of learned counsel Miss S. Mary,
Yes.
has prayed for adjournment. List this matter. You have taken consent from the other side?
Yes, ma'am.
Consent is obtained from the other side. List this matter when do you want?
After 3 weeks, ma'am.
After 3 weeks.
Much obliged.
May I please, your lordship?
Yes, yes.
My lord, I'm appearing through virtual.
Yes, yes. I saw you just now,
Yes.
but you have disappeared now.
No. Oh. Yes. Am I visible, my lord?
Yes, now you're visible. Yes.
My lord, there are 2 items. Item number 6 and 7. Yes. The
Six and
item
7.
number. Yes. Item number 6 is with respect to a matter where I was being terminated without the applicability of the service rule of the Nagaland University. And in that matter, item number 5.
Item number 5 and 6.
In that matter, Mr. C.T. Jamir, senior counsel, is appearing on behalf of the Nagaland University. Affidavit has not yet been filed till now because this is his first appearance.
Your Lordship, we have filed that,
So
They have
what-
filed affidavit today.
but we couldn't serve it to the petitioner because
They have filed affidavit but could not serve the affidavit.
So what I am saying is that let them serve a copy to us and let this matter be fixed on 16th 17th of September.
Okay, all right.
Okay, ma'am.
And
Item number 6.
item number 5. This is item number 5.
5.
Yes,
Okay.
5. Item number 5.
Okay, item number 5 for Likhason, learned counsel Mr. S. Borgohain is present for the petitioner and has prayed for adjournment as the petitioner has not received a copy of the affidavit. Yes. Okay. Oh, will I have to take the items together?
Yes.
No. That's what I'm coming on second thing.
Okay,
As
okay.
far
Let me complete this order then.
Yes.
Okay. Yes, learned counsel.
I'm Ms. Tushi Jamir.
Learned counsel Ms. Toshi Jami has submitted that affidavit has been filed for respondent number 2 and 3.
2 and 3.
Learned PP, Mr.
My Lord,
It is not required, my lord. It is not
in
required.
item number 5, I'm not appearing, my Lord. In item
Item
number
number
6.
5, okay. Learned PP nalage, huh? Respondent number 2 and 3, okay. List this matter on 17 September.
Yes, my lord.
17 September, all right.
Yes.
Then item number 6.
Item number 6 is wrongly listed today. It was supposed to be listed tomorrow. That
Okay.
was on 21.
Okay.
So because both the petitioners are the same person, one is with the service matter, another was with the criminal matter. So as far as item number 6 is concerned, there was a direction issued by this honorable court that till this matter is pending adjudication, the trial court is not supposed to proceed with the matter. Your honor my lord can see that order passed by this honorable court. So what I am saying is that since it has been wrongly tagged, let this matter come up on 18th of September and the earlier direction passed by this honorable court to continue.
Okay. All right.
Yes, my lord.
Learned Counsel Mr. S. Borgohai is present for the petitioner and is prayed for adjournment. Learned PP Mr.
Thipa
Khom, na?
form, yes.
Thipak Phom is present for the state of Nagaland. List this matter on 18th of September. The order passed on. Which was the earlier order?
Earlier order was of, my lord, just a minute.
Interim order.
Yes, interim direction was.
Interim
direction.
order shall remain in force till then. All right.
Yes.
My lord, can it be reflected that it is Mr. Borgohai is not requiring adjournment? It has been wrongly listed today. Kindly put it that way, paraphrasing it.
Sorry.
Let it be reflected that this matter was wrongly listed today. As
Okay.
far as the earlier.
Our line idea, second line idea. Learned Counsel has submitted that the matter has been wrongly listed today. All right.
Yes,
What is this?
18.
Much obliged.
Yes, 18.
Obliged. Obliged.
May it please your lordship.
Oh, okay. Wrongly listed. Just a moment. There was an order in criminal petition 23 that lists this matter along with WPC 100 of 2026.
No, what happened was that in that case, that when the matter was coming up on the last occasion, Honorable Justice Y. Lankumar Madam was presiding. Both the court number 1 was not sitting, so we told the court that there are two matters of the same person, but since the other court is not sitting, Justice P.J. Soika was supposed to list. He left the court because of a casual leave. So my interim direction was going to be expired. So the court told it, okay, we'll take it up together. That's why it came up. But as far as the connection of this matter is concerned, integrity is not related.
All right.
May it
Obliged.
please-
Yes, yes.
My lord, I beg to mention item number 7 hearing.
7? Yes. Yes.
My lord, I'm the petition in this particular case. But the respondent number 1, he said he doesn't get a link. So I want the matter to be adjourned.
Oh, it's not getting linked.
Yes, yes. So he's asking for 1 month time.
Okay.
Yeah.
As agreed by both the sides,
Yeah.
list this matter on
After 1 month is what.
after 1 month. Learned Counsel Mr.
Elevil Zhao.
Erivil Zhao is present for the petitioner.
My lord. Obliged.
This Lordship.
Mm.
Lordship, I'd like to mention item number 4, Lordship.
Mm.
Here, I'm yet to receive instructions, Lordship. So if 3 weeks time you granted to me, Lordship.
Okay.
Item number 4.
Yes, name?
Shisa Jamir.
Learned Counsel Ms. Shisha Jamir is present for the petitioner and learned government advocate.
Yes, Lordship. S. Chang.
Ms. S. Chang is present for the
Respondent
State-
1-5.
respondent number 5 and has
1 to
prayed,
5.
huh?
1 to 5.
Respondent number 1 to 5 and has prayed for time to file what?
Affidavit.
Affidavit in opposition. List this matter after
3 weeks, Lordship.
3 weeks.
Much obliged, Lordship.
May it please your ladyship, may I mention item number 3?
Yeah.
Your ladyship, here I find my affidavit and copy duly served to the petition.
You have filed objection today.
Yes.
Learned Counsel Mr.
Boko.
Puko.
Yes, Your Honor, since I've received this morning, I may be allowed granted 3 weeks.
Yes, yes. Learned Counsel Mr. Puko Lam
Yes.
is present for the petitioner and has submitted that today he has received a copy of the objection and has prayed for 3 weeks time to file reply.
Reply.
Learned Counsel Mr.
James Newman,
J.
private respondents.
James
Newman.
Newmar is
Yes.
present for private respondent number 6.
Yes.
Anybody present for government?
Your Lordship,
They have filed their
at this
affidavit.
post.
Okay, all right.
Government, they have filed their.
Okay. List this matter on after 1 week, 2 weeks.
4 weeks.
All right, all right. List this matter after 4 weeks.
Much obliged.
For motion, item number 1.
May I please your Lordship. Lordship, this is a matter praying for regulation of service of the
Mm.
petitioner for pension and other retirement.
How many years you are continuous in continuous
Uh,
service?
Your Lordship, I was released from service on 29 February 2024 on attaining the age of 60 years. I was superannuated.
Our superannuation.
Yes, I've served the
All right, all
for
right.
26 years. in
You were serving as
Work church
work
later.
house. All right, will issue notice. Learned Counsel, Mr.
Manjong.
Manjong Konyak is present for the petitioner, and learned government advocate Livika
AIME.
AIME is present. Learned government advocate Miss AIME is present for the how many respondents?
Respondent 1 to 7.
Respondent number 1 to 7, and has accepted notice on behalf of the respondent numbers 1 to 7. Thus, no further notice is required to be issued. Extra copies to be furnished during the course of the day or within 2 days. Extra copies to be furnished within 2 days. Any other respondent?
No, Your Lordship, only
Okay.
government.
List after how many days?
After 4 weeks, Your Lordship.
After 4 weeks.
Right.
Item number 2.
Hmm.
May I please, Your Lordship?
Yes, yes.
Your Lordship, the petitioner is approaching for regularization
After retirement or before retirement?
before retirement.
Same order?
Yes,
Oh,
Lordship.
তুমি গুছি গলহি. Okay. What is your name?
Tushi Tumchin.
Learned Counsel Mr. Tushi Temchen. Tushi Temchen is present. Tushi Temchen is present for the petitioner, and learned government advocate Miss
IME.
AIME is present for the respondent number
1 to 5.
1 to 5 and has accepted notice on behalf of the respondents who stop thus. Formal notice is not required to be issued. Was that? Extra copies to be furnished within 2 days. Any other respondents?
No, Lordship.
List after 4 weeks, 3 weeks?
3 weeks,
List
Lordship.
after 3 weeks.
Much affection.
From the supplementary cause list for motion, item number 12.
May I please,
Mm.
Ladyship,
Hmm.
Your Ladyship, this petition was filed seeking us very limited direction before by this honorable court.
Hmm.
Lordship, I have executed a work for construction of an ESU office under Mon district. Now the construction was completed in the year 2016. Now, before completion of the work,
Hmm.
an additional work was also allotted to the petitioner.
Mm.
Now he has completed that additional work in the form of constructing fencing, security fencing, Lordship. That was proposed by the department. Now, a committee was constituted for inspection of such work, and a report was submitted. Now, after submitting the report, Lordship, there was no positive action taken by the respondents. So, therefore, I have approached, and the Deputy Commissioner's Office, MON, they have submitted a proposal to the government. Now, the proposal was replied by the government in the year 2024, stating that there is financial constraint. That is the only issue, Lordship.
What?
Otherwise,
Financial constraint.
yes, Lordship. And that communication was made in the year 2024. Now, I have been waiting for more than 2 years now after the government has expressed their
They'll
difficulty.
obtain instructions.
Lordship, a very simple direction if it can be issued. So within a time frame, if the amount can be paid, because the amount is admitted, Lordship, by the respondents.
Your Lordship, let notice be issued.
My respectful submission is, Lordship, even if notice is issued,
Yeah.
and if the government files the affidavit, it will be the same stand because they have already taken the decision.
Let her obtain instructions. Let-
Lordship.
You obtain instructions, will issue notice, you obtain instructions. Learned Counsel Mr. Muazzami is present for the petitioner, and learned government advocate Miss AIME is present for the respondents. All the respondents are,
1 to 5, yes, Your Lordship.
there are more respondents?
No, no.
Respondent number 1 to 5. Full stop. Notice is accepted by the learned government advocate and the government advocate, no?
Yes, Your Lordship.
Senior?
No, no. Your Lordship.
Notice is accepted by the learned government advocate, and thus no formal notice is required to be issued. Full stop. However, extra copies to be furnished within 2 days. Full stop. The learned government advocate is to obtain instructions if the what is this amount?
15 lakhs, 7,000.
No, not the amount. It is called as pay or what? Bill amount.
Pending bill amount, Lordship.
obtain instructions if the pending bail amount which has been not paid for more than 2 years can be paid
Lordship.
to the petitioner. List this matter after 3 weeks.
Lordship. Obliged.
For orders, item number 11.
Please, Your Lordship.
Yes.
By this application, I am seeking to amend the writ petition
Mm.
to incorporate one additional document which has been discovered from the counter affidavit filed by the private respondents. That document was not within the knowledge of the petitioner at the time the writ petition was filed. So I'm seeking leave to amend the petition. I've taken over to the private respondents to the opposite parties as well.
They're present or you?
Yes, the private respondent is here, but
Okay.
I have
We
no
can,
objection.
you do not have any objection. Okay, we'll allow them. Okay, we'll allow them. There was item number
11.
11, no? Learned counsel, Mr.
L. Irali.
L. Iralu, learned senior advocate, no?
No.
Okay.
Assisting the senior.
Okay, learned counsel, Mr. L. Iralu is present for the
Petitioner.
applicant,
Applicant.
for the petitioner stroke applicant, and has filed this application with prayer to, where's the prayer?
There will be a page 11, 10, 11.
Amend,
Yes, to amend.
amend the WPC number 54 of 2026 in terms of the proposed amendments
Paragraph.
sought at paragraph 5 of this application
Yes.
as follows. Paragraph 5 to me, page 6, tick mark D as follows. And column to D play, hyphen D diva. 9.1 or page 6, 9.1 to
Page 10.
page 10.
Yes.
9.1 or continue to 9.7 hobo, kinto call 7 will likhase, page 10, jot tick mark hek hose tumi tat hek kori diba. 2 kilowatt tat hek kori diba. Learned counsel Mr. Wati Zamir is present for respondent number 3 to 10 and has submitted that he has no objection if the petition is allowed to be amended. Anybody is present? Nobody. Considering the submissions at the bar, the petition, the amendment as prayed for is allowed. Petitioner stroke applicant to file an amended, file the amended petition
Within a period of 1 week.
within 1 week. It'll club koi likhi diba, I or WPC to club koi likhi diba.
Very good. I'm-
Within 1 week, list accordingly.
For hearing, item number 8.
Item number 8.
If your ladyship remembers, it was part heard on Monday. No?
I forgot.
The state respondents, they were supposed to file an affidavit enclosing the office memorandum for invalid pension.
For what?
Invalid pension, Lordship.
For what pension?
Invalid, granting of invalid pension. If I may be allowed to refresh your Lordship's mind by referring to just 1 or 2 facts.
Okay.
Lordship, I have served for 7 years, 7 months and 10 days as a constable.
Oh, yes. Now I remember.
And I have been
Invalid pension.
Yes, Lordship. A medical board has been constituted, and the department is also of the knowledge that I have such difficulties. So I have submitted a representation. The representation was not considered, which is why I was before the Honorable Court, Lordship. Now the state respondent's contention is that there is an office memorandum issued by the government of Nagaland saying that the qualifying length of service should be at least 10 years. Which is
There are judgments of this court.
exactly, Lordship. Exactly, Lordship. Now I have also enclosed one of the judgments, and
And
if
that
necessary-
this notification has been taken care of in the judgment.
yes, Lordship.
Which is the judgment?
Lordship, I have enclosed.
According to you, this is a covered case.
It is a covered case. even the facts which I have relied upon
Mm.
are similarly situated with.
Which is
present
the
case.
judgment? Which is the judgment?
Judgment is at page 26 of my read petition law.
Page 26 of the.
Page
petition.
26.
Yes, okay.
Page 26.
Yes, yes.
It's a
It is-
short
it is-
judgment.
It has already been noted.
Yes. Yes, Your Lordship. Now the rule 38 is very clear. The requirements under rule 38.
Uh,
I fulfill all the requirements.
You have given the rule,
Yes, Lordship. The relevant
only the relevant page, no?
page, rule
Can you give me
38.
the entire rules? Typed or printed or anything? Entire rules? He has
Yes,
given
pension rules.
pension, local pension rules of 1965, 67, 72.
1972.
Okay, 1972. You want to say something?
Let the petitioner complete his submission.
He has completed, I think.
Only one authority.
One more.
Only one authority. That is the clear copy of the relevant page of the CS pension. rules.
Authority, which one?
Rule 38, invalid pension, page 184.
Local rules, no? CCS? Nagaland, it's not the central service rule.
Your Ladyship, I'm referring to the Central Civil Services
So
pension.
you are referring to the
Yes.
central service rules. Okay.
Central Civil Service.
Hmm. Rule 38.
Rule 38, which is a part of the read petition.
Hmm.
I have enclosed it at page 28 as annexure 8. 24 as annexure 8.
Yes, rule 38.
Rule 38.
Hmm. Rule 38, invalid pension.
Invalid pension.
Hmm.
May I read it here?
The day you have read, I
Yes,
think.
yes. So
You
it is
can,
very clear.
you can read if you want to read.
Just to refresh the
Hmm.
mind of this honorable court. Page 24, Rule
Hmm.
38. May I read it?
Yes.
Invalid pension may be granted if a government servant retires from service on account of any bodily or mentally infirmity which permanently incapacitates him for the service. Sub-rule 2, a government servant applying for an invalid pension shall submit a medical certificate of incapacity from the following medical authority, namely a medical board in the case of gazetted or non-gazetted government servant whose pay as defined in Rule 921 of the fundamental
So
rules.
he has approached the medical board also?
Yes,
And he has the certificate also?
Yes. A medical certificate was issued,
Hmm.
page 15 of the writ petition.
Okay.
It consists of 3 members board. They have certified that I suffer from 40% of disability. Now that certificate suffices and it fulfills the eligibility criteria or the requirement of Rule 38. Now the only contention is that there is a executive instruction which exists at the
Notification.
state of government and not by way of an office memorandum, which was finished in the additional affidavit which was filed. It is office memorandum dated 22nd December 2015.
Yes.
Guidelines on invalid pension,
Hmm.
page 7 of the affidavit filed by the state respondents. I have received this morning, Your Lordship. Respondent number 4.
Hmm.
If your ladyship queried, may I read the office memorandum?
Yes, you can read.
Guidelines on invalid pension. It has been observed that cases of sanctioned of invalid pension are referred to P&A department by other departments for concurrence, even though the government employee concerned has been released from service by the respective department before the employee completed a mandatory 10 years of qualifying service required for invalid pension. In this regard, attention is invited to Rule 38, read with Rule 49 of the CCS pension rules, wherein if an employee has put in a qualifying service of less than 10 years at the time of retirement, he or she is not entitled to pension but he is entitled to service gratuity only. In order to be eligible for invalid pension, a permanent temporary government servant must have rendered not less than 10 years of service. That is the standard of the state government. Now, the rules framed under 309 is very clear. There's judicial pronouncement, and there's also other authorities that says if there's a conflict between the rules framed under 309 and the executive instruction under 162, 309 will prevail. Besides that, there is also judicial pronouncements, which I have also enclosed. On that, if I may be allowed to refer to just one judgment.
Sure.
Just one paragraph. It is in the case of Ashok Kumar's case, which is reported in 2013 SCC. Paragraph 58, 59, and 60. Page 172.
58, 59,
And 60.
60.
May I take your leadership
Yes,
to
yes.
page 172.
I've already got it.
May I read it?
Yes.
A constitution bench of this court, while dealing with a similar issue in respect of executive instructions, it is held that it is true that the government cannot amend or supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, the government can fill up the gaps. There is no silent. Rule 38 is very clear, Lordship. So there's no silent. And supplement the rules and issue instructions not consistent with the rules already framed. Rules are already framed. Rule 38 is crystal clear. It says that invalid pension can be granted regardless of the length of service he has rendered. Now, for paragraph 59, the law laid down above has consistently been followed, and it is a settled proposition of law that an authority cannot issue orders, office memorandum, executive instructions in contravention of the statutory rules. Now, statutory rules in this case is the rules under rules of 1972. However, instructions can be issued only to supplement the statutory rules and not to supplant it. Now, by issuing this office memorandum, the state government is trying to supplant, not supplement. Such instructions should be subservient to the statutory provisions. 60. Similarly, Constitution bench of this court in Naga People's Movement for Human Rights held that the executive instructions have binding force provided the same have an issue to fill up the gap between the statutory provisions and not inconsistent with the state provisions. And this executive instruction is inconsistent to the rules framed under 309. Therefore, the rules will prevail, and I'm entitled to the invalid pension as provided under Rule 38. That is my respectful submission, Lordship.
Okay.
May I please allow? Lordship, I'm for the state respondent, Lordship. Lordship, we have filed our affidavit in opposition, and there we have clearly stated regarding the stand of the state respondent, Lordship. Lordship, we are also aware of the fact that in Tarsim's case, Lordship, the Honorable Apex Court has granted the invalid
case?
pension. Tarsim's case, which was relied by my learned friend,
Just now.
Lordship.
It's part of the read petition.
It is part of the read petition.
Okay.
And they have relied on this, Lordship. I also totally agree with the Apex Court decision, Lordship. However, Lordship, if Lordship may kindly come to the Rule 38 of the CCS pension rules, Lordship,
Yes.
as referred by my learned friend. Lordship, here I would like to rely on one paragraph. Lordship, if Lordship may kindly come to the Rule 38 invalid pension, Lordship.
Paragraph. Which paragraph?
Paragraph 2 in the note 1. Note 1. Note 1. If I'm allowed to read, Lordship.
Yes.
Lordship, in the note 1, it says that no medical certificate or incapacity for service may be granted unless the applicant produces a letter to show. Very important here, Lordship. The applicant produce a letter to show that the head of his office or department is aware of the intention of the applicant to appear before the medical authority. Lordship, here I would like to pause for a moment, Lordship. Lordship, it is the head of the office who has to constitute a medical board, Lordship. Lordship, if Lordship may kindly come to my affidavit in opposition, filed on 14 June 2023.
I think I remember that he had approached, that was what he has submitted last time.
I would like to come to that extent, Lordship. Lordship may kindly come to the affidavit in opposition filed by the respondent number 1, 2, 3, and 4, Lordship. 4 June 2023, Lordship. From the record, I would like to show your Lordship that page 10 and the type copy is at page 11, Lordship. Affidavit in opposition filed by respondent number 1 to 4. Lordship has got it.
Affidavit in opposition for
Filed by
respondent number 1, 2, 3, and 4.
Lordship may kindly come to page 10.
No, just a moment. There's no page 10 here. Oh,
Page
yes,
10,
yes,
and
yes.
Annexure A, and the type copy will be at
Annexure A, yes. Page
11. Type copy is at 11. Page 11.
Yes.
If I may allow to read this, the resignation, discharge from service, resignation rendered by the petitioner Lordship. To the Commandant 11 NAP IR Battalion, Chumukdima, Nagaland, subject discharge from service. Sir, with due respect, I have the honor to inform you that due to my poor health, I am unable to perform my duties. May I therefore request you to kindly discharge me from the service so as to enable me to take care of my health. For your kind consideration, I shall be thankful to you, sir. That is the only grievances that has been addressed to the Commandant, Lordship. Lordship, here the Commandant could have ought to have placed it before the higher authority, Lordship, to constitute a medical report, Lordship. But
I
here
think
is
it's constituted, I think.
Lordship, in fact,
He had shown me last week, I believe.
Lordship, but Lordship, from the reading of Rule 38, Note 1, Lordship. Here it clearly from the interpretation of Rule 38, Note 1, Lordship. It said that it also states that the medical authority shall also be supplied by the head of office or department in which the applicant is employed, and with a statement of what appears from the official to be the age of applicant. If a service book is being maintained for the applicant, the age recorded therein should be reported, Lordship. So, Lordship, the Commandant, Lordship, Lordship, they have produced the certificate. I'm not saying that this is not proper, Lordship. In fact, they have submitted the certificate of disability. That we agree, Lordship. But as per the procedure, Lordship, because of that, Lordship, we have filed an additional affidavit, as Lordship has directed us to file an additional affidavit by placing the office memorandum on record, Lordship. So, Lordship, if Lordship may kindly come to the office memorandum, Lordship. Here, the office memorandum states that the mandatory is 10 years, Lordship. But I agree with the Tarsim's case, Lordship. In spite of that, Lordship,
Yes.
I agree with that. But however, Lordship, there are certain procedures where, as per the office memorandum, that has to be followed, Lordship. Lordship, from the office memorandum, from there it states that prior clearance from PNR department, Lordship. And Lordship, moreover, for if at all the referring department have sent a proposal for invalid pension, then they have to specify and propose the date of retirement, Lordship. So, Lordship, simply issuance of this order by the Commandant, Lordship, in my respectful submission, Lordship. In my respectful submission, the Commandant could have placed it before the higher authority, Lordship, so that, Lordship, in the meantime, a proposed date of retirement is also required, Lordship. Lordship may kindly come to the additional affidavit, Lordship, which recently I have filed, Lordship. We have filed, Lordship. Page 7, Lordship. So as far as 10 years mandatory, I'm not into that, Lordship. However, Lordship, additional affidavit, page 7, Lordship.
I cannot find the additional affidavit.
Lordship, I have filed yesterday, Lordship, 19.
I think it's
Yes.
not on record, additional affidavit.
If
I'm sure. Affidavit. Affidavit.
additional affidavit filed
Ah.
on 19 August.
This is very, part 2. Okay.
If Lordship may.
Yes, I got it.
Lordship,
Page
kindly
three.
come to page 7, Lordship, Annexure B. I will only read the operative portion, Lordship, since I'm not into 1, 2.
Hmm.
If I'm allowed to read, Lordship.
I think he has read it.
Lordship. So, Lordship, there are the certain, in view of the position stated above, the following procedure may be followed while processing such cases henceforth. A. Prior clearance of PNR department may be obtained by the government servant is released from service on invalid pension. B. While forwarding the proposal for invalid pension, the referring department, the department may specify the proposed date of retirement, Lordship. Very important. The proposed date of retirement. And secondly, and shall also furnish the service book and medical board recommendation, Lordship. And Lordship, the third medical board recommendation, which I'm making my submission before this honorable court is, Lordship. There is no medical recommendation as such by the head office, Lordship. So, Lordship, my humble submission before Lordship is the commandant could have place it before the higher authority for recommendation of this medical board, Lordship. However, that was not constituted. And Lordship, from the face of the record, Lordship, from the affidavit in opposition filed by the state respondent, Lordship, from their Lordship, it also appears that they have not annexed any documents as such, but I'm not into that, Lordship. And I'm also not into that they have submitted the certificate, disability certificate. I'm not saying that is not proper, Lordship. But however, there is a certain procedure which has to be followed by the respondent authority to avail the invalid pension, Lordship. So now the problem will arise. What will be the proposed date of retirement? That also is not aware, Lordship. And secondly, Lordship, board recommendation is not there, Lordship, in total, Lordship. So, Lordship, basing on the rules, CCS pension rules, Lordship, since the petitioner has forfeit his service or resignation, Lordship, Rule 26 says that resignation from service or a post, unless it is allowed to withdrawn in the public interest by appointing authority, entail forfeiture of
Where are you reading?
past service, Lordship. This is the CCS pension rule. Pension rule, which Rule 26, Lordship. Rule 26, which I have also stated in our affidavit in opposition, Lordship. Rule 26. Rule 26, 1 and 2, Lordship. Subclause 1 and 2.
Same, no? Yes, please read.
Rule 26, subclause 1. Resignation from a service or post, unless it is allowed to the withdrawn in the public interest by the appointing authority, entail forfeiture of past service. 2. Registration shall entail forfeiture of past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government, where service qualifies, Lordship. Lordship, from this, Lordship, since the petitioner has tendered his resignation, and from the clear reading of the resignation letter which was submitted, Lordship, this is only to do with discharge from service, Lordship. Accordingly, the Commandant 11 NAP, Lordship, has discharged, Lordship, the petitioner.
Where have you shown me the discharge letter? In the petition, no?
Lordship, page 11, Lordship.
Of the
Type-
petition?
Of the affidavit in opposition filed by respondent.
Okay, page 11 of the.
Page 11.
Affidavit in opposition.
Page 10 is the
Page
is,
11 of the affidavit in
resignation.
opposition.
Lordship, and page 11 is the type copy. And moreover, Lordship has rightly pointed out, Lordship, on the last occasion, Lordship, since they have not challenged the office memorandum, Lordship, they could have challenged the office memorandum.
No, but it's not required now to challenge the office memorandum.
Lordship, if that may be, Lordship, but however, Lordship, Rule 38, Note 1 clearly states that it has to, that intention of the applicant has to be in the knowledge of the head of office, Lordship, and which was not followed, Lordship, in the present case, Lordship. So, Lordship, my humble submission on the last occasion I was mentioning, Lordship, I was making a submission, since they have filed a representation before the authority, Lordship. If
Just a moment, you see. These rules came into force. Your office memorandum came into force.
2015.
December 2015, and this was passed in 2000 and this order was passed in September 2015. How will you comply to this office memorandum? When the office memorandum has come on September to December after the order was passed, how will you comply, you see?
Lordship, even otherwise, Lordship, since medical report, Lordship,
That note one,
recommendation,
that note one.
Lordship, that recommendation has to be there, Lordship. As per the rules, Lordship, since our learned friend is also relying on Rule 38, Lordship. From the Rule 38, Note 1, it's clearly stated that that intention has to be brought to the knowledge of the head office, Lordship. And Lordship, if Lordship may not agree with the office memorandum, but Lordship, from the office memorandum also, there is a certain procedure where it
But
has.
see, how will he comply with the procedure? He was discharged on September, and the office memorandum came out in the month of December.
Lordship, as far as the said respondent is concerned, Lordship, he was discharged from service as per the Rule 26, Lordship.
Rule
Since
26.
Rule 26, Lordship, not as per the Rule 38.
Not as per Rule 38.
Lordship, since
So according to note one, you have to give the age. So that note one has been improved and made into office memorandum that you'll have to give your date of retirement also.
Lordship, the proposed date has to be there, Lordship.
For
Proposed date for
date of
retirement, Lordship,
yes.
Lordship. There is no such
So
law.
that OM is a part of note one also.
Lordship. So our line of argument will be Rule 26, Lordship.
All right.
And Lordship, I would like to place one authority that is with regard to delay in leges, Lordship.
Where is the delay here?
Delay of 6 years, Lordship.
Okay.
And Lordship, in the earlier filing my affidavit in opposition, Lordship, we have also raised a preliminary objection on 2 grounds, Lordship. One is on delay in leges, one is non-gender of the necessary party. However, in the course of hearing, Lordship, the commandant who was in necessary party has been amended by the Learned Counsel for the petitioner, Lordship. And thereafter, Lordship, I'm not into that, but Lordship, however, regarding the preliminary objection 1, that is on delay in leges, Lordship. Lordship, I will only read the operative portion. This is 2022-15 SSC. I'm relying on paragraph 8, Lordship. Para 8. If I'm allowed to read, Lordship. Para 8. As observed by this court in a container of decisions, mere representation does not extend the period of limitation, and the aggrieved person has to approach the court expeditiously and within a reasonable time. If it is found that a writ petitioner is guilty of delay and leges, the High Court should dismiss it at the threshold and ought not to dispose of the writ petition by relegating the writ petitioner to file a representation and or directing the authority to decide the representation. Once it is found that the original writ petitioner is guilty of delay and leges, such order shall not give an opportunity to the petitioner to thereafter contend that the rejection of the representation subsequently has given a fresh course of action, Lordship.
I think he has also relied on,
So-
on judgment relating to delay.
Lordship.
I think so. Last 3
last-
years relied on
Lordship.
judgment.
So, Lordship, since he was discharged from the service, Lordship, earned leave of rupees, earned leave as well as from the GBF final withdrawal, Lordship, 1,49,900 has been paid to the petitioner, Lordship. Since the petitioner has forfeited his service, Lordship, basing on that, Lordship, whatever GBF that the petitioner has been depositing, that has been withdrawn, Lordship. And that also we have stated in paragraph, more particularly paragraph 6. That is my answer.
Wait, please, Your Ladyship.
Hmm.
Your Ladyship, as far as the memorandum is concerned, that is already fully understood
Yes.
by this Honorable Court. So I will not go into that.
Yes.
I have only 2
So
submissions.
for
I'm for the Respondent Accountant General Office.
AAG. Okay.
So Your Ladyship, number 1, the Rule 26 of the CCS Pension Rules 1972. The plain reading of that, I'm submitting as a counsel assisting this Honorable Court, not in favor of any party here.
Yes.
Now, Rule 26, if we have to appreciate it in its actual context, if we have to have a general understanding, then it appears to show that since he was discharged from service on resignation, no further benefit entails from the service that he has rendered, the past services. But if we read carefully, it does not say anything about on the grounds of disability. So that I will leave the interpretation to this Honorable Court. Number 2, now we are a welfare state. So if a person working under me and I as a supervising officer, if a person is suffering from disability and approaches me, I am supposed to guide my junior on how to apply for it.
Yes.
Because benefit is just thrown out of the window, which
Yes.
I feel is unfair, Your Ladyship. So the letter, which is at page 11 of the state's affidavit, I feel that it is there is a lacuna which has been created by the controlling officer himself. So with that submission, I leave it to the wisdom
Yes,
of this own court.
He is supposed to know all the rules. The controlling, drawing and disbursing officer is supposed to know all the rules, not the incumbent.
Yes, Your
They will
Ladyship.
not know. I think he was working as chokidar. Or what?
Constable.
He is just a
Constable. How
constable.
will he know? He'll not be aware.
Lordship, that we agree. That we.
May I just on one or two aspects,
Mm.
Your Ladyship? The Learned Counsel for respondent number 5, the Accountant General's office
Mm.
has read out 26,
Mm.
which is very clear, and I'm grateful to the Learned Counsel.
Mm.
Now, this rule 26, it's a general rule. It's for general resignation from service.
Mm.
It should not be read conjointly with Rule 38. It has to be read in isolation, both the rules, 26 as well as 38.
Yes.
38 is an exception.
Mm.
It's for exceptional cases, Your Ladyship.
Mm.
It is for those employees having difficulties or disabilities,
Mm.
and it should not be read together with Rule 26
Mm.
or even Rule 49 for that matter.
That OM is, I think they have joined the Rule 49 in the
49
OM.
and 38. With due respect,
Mm.
it is a misinterpretation of the CCS Pension Rules 1972. Therefore, Rule 26 will not apply in this case. Office memorandum, Your Ladyship has rightly pointed out, it cannot have retrospective effect. It was passed or issued only after the retirement of the present petitioner, so it won't have any retrospective effect. Even otherwise, executive instruction cannot override the rules framed under 309 of the Constitution. Now, with regard to the question of delay, which I have, which the Learned Counsel for the state has pointed out, there's a delay of 6 years. Now, the authority which I've relied upon, there was a delay of 28 years. And it has discussed.
You have joined the authority, you have given the authority?
Yes.
Submitted?
Yes.
Along
Page
with
26
page
of the
26,
petition, page 26.
All right.
Because this authority has discussed on 3 facets.
Mm.
3 facets.
Mm.
The first is whether 38 and 49 can be considered together. That is one aspect.
Mm.
Second, the question of delay has also been addressed at length by even discussing the celebrated judgment of Tharsim Singh's case on the question of delay. Now the question of delay does not arise here. And there's also settled principle of law, which Your Ladyship
Only the
were
exception is
aware.
that note 1,
Yes.
there's a one single glitch, that note 1 of the Rule 38.
Yes, I'll come to that note.
Mm.
I'll come to that note. It is a settled principle of law that in question for delay, for pension, the question of delay does not arise for pension because it is a continuing wrong. It causes continuing injury to the employee concerned. So the question of delay does not arise for pension.
Mm.
It has well-settled principle. So I'm not referring to any judgment, but Tharsim Singh's case will cover my case. We'll take care of it. Now, interpretation of this Rule 38, my learned friend has referred to note 1. Note 1, the intention and the knowledge of the controlling officer. In fact, my learned friend was arguing against himself because he has pointed out some lapses on the part of the respondent number 6, the controlling officer, who was supposed to guide, take care, and let him be aware of the procedures being followed. Because there are numerous employees working under him. He is supposed to know all these provisions. Even otherwise, he has issued a note expressing that he is under the knowledge that the employee concerned has some difficulties. He is also very much aware of the medical board, the certificate issued by the medical board. So my respectful submission, Rule 38, the requirements under Rule 38 has already been fulfilled. and he is very much entitled to pension under Rule 38. The note says intention. The intention has been taken care by the note issued by the controlling officer. Everything is covered, taken care of.
Okay, I'll dictate the order. I think it will not take very long. I'll come back after 5 minutes and dictate the order. মাতি দিয়ে এজন মাতি দিয়া তোৰ লম্বা হ'ব অলপ তুই বহিলা ন বহুত দেৰি মাতি দিয়ে এজন This is an old case, no? Very thick order sheets.
It was filed in year 2021.
Oh, no wonder. I thought this is the petition, but I have seen this is the order sheet. Pile of order sheets.
In fact, when the matter was heard once in year 2024.
Oh,
Some report has passed direction to implement respondent number 6 the comment.
oh, after complete hearing of the, which is the order?
The year 2024,
2024,
month of July,
July. July 24.
4th July 2024.
Then I'll get the story here. Then she won't have to. For July 24.
4th July 2024.
Okay, no, the story is not here.
Maybe the tired argument was not important.
Okay. Now I'll have to dictate the story. So I thought this is the petition, but it's not the petition. This is the petition. Okay, heard learned counsel Mr. Muaz Emri for the petitioner, former learned government advocate Mr. V. Jimomi for the respondent number how many? 1 to 4. And learned counsel Mr. Joshua Sheki, standing counsel? Huh? Standing counsel for?
Respondent number 5, accountant general.
Oh, learned standing counsel for the accountant general, comma, respondent number 5. It is submitted by the learned counsel for the petitioner that he was enlisted as constable within bracket capital G bracket close D with regiment REGT, number REGT number 111298 within inverted single inverted commas capital ADM COY company, COY, comma, by office order number Roman 11 NAP within bracket capital IR bracket close stroke RO -2 stroke 2007 -08 stroke 3081 dated 7/2/2008 full stop. After serving the department for 7 years, 7 months and 10 days, comma, the petitioner submitted his resignation letter on account of disability, to which effect certificate number 514, comma, dated 8/9/2015 was issued by the medical board consisting of 3 doctors,
Yes.
3 medical officers, constituted. Oh, okay, consisting of 3 medical officers. No, it will not be medical officers. Which page? I think they will be superintendent.
Page 15.
Little bit of higher rank, I think. Consisting of senior specialist, comma, medical officer, comma, senior specialist and 2 medical officers. Senior specialist and 2 medical officers, full stop. The certificate was issued on 8/9/2015. Okay? The petitioner submitted representation dated 22/4/2021 to the Director General of Police, within bracket respondent number 4, bracket close, praying for payment of invalid disability pension and other service benefits. It is submitted that till date, the representation has not been disposed of. As per Rule 38 of the
Yes.
Central Civil Service Pension Rules, within bracket, CCS rules for short, bracket close, 1972, the petitioner is entitled to invalid pension within single inverted commas, invalid pension. The certificate issued by the F. Coy Commander, marked as Annexure 3 of the petition, clearly reflects that the petitioner had informed the company commander, the COI commander, COY, COI commander, about his poor visibility, poor eyesight, no?
Yes.
Poor eyesight, poor visibility, full stop. The petitioner has properly complied with the mandate of Rule 38 and he is entitled to invalid pension, full stop. The petitioner has resigned from this I have dictated, no? 7 years, this I have dictated, yes. It is contended that, next paragraph, it is contended that for nearly 5 years, the authorities did not consider the petitioner's pension, which impelled IMPELLED the petitioner to file a representation to the Director General of Police, Nagaland. All right. This representation is marked as Annexure 7 of the petition. Per contra, the learned counsel for the respondent number 1, 2, 4, learned counsel, no, learned advocate, learned government advocate, learned government advocate for the respondent number 1 to 4, laid stress in his argument that the petitioner is not entitled to pension.
Lordship, it will be 1 to 6, Lordship. 1 to 4 and 6, Lordship.
1 to 4 and 6.
Lordship.
6 is the comment, says the
Six
duly
is the
written.
comment, duly.
Okay, company commander. Okay.
Lord.
Yes. Thank you. You must correct me now and then because I have forgotten. I read the order also, even then I have forgotten. It is per contra, the learned government advocate laid stress for respondent number 1 to 4 and respondent number 6 that the petitioner is not entitled to the invalid pension as per Rule 38. Full stop. The learned government advocate has drawn the attention of this court to the office memo dated. This is your new 19 August, no? Okay. To the office memorandum number. Office memorandum number. After writing office memorandum within bracket, OM for short, bracket close, number PAR, capital PAR, stroke 1 INV, not 1 INV, space PEN hyphen 8/2015 dated Kohima the 22nd of December 2015, comma, marked as Annexure B of the affidavit in opposition. It is emphasized that emphasis has been laid on the office memorandum stating that and that any employee is entitled to invalid pension only after 10 years of service, not only after 10 years of service, and as the petitioner has served the government for around 7 years or more, comma, he is not around 8 years, 7 years, 10 months, no? For more than 7.5 years, for more than 7.5 years, comma, he is not entitled to the invalid pension, full stop. It is also submitted that note 1 of note 2.1, no? 3.1.
2.1.
No, it's not 2.1. There is a 3 also. There is a 3 also.
Note 1.
It is submitted that note 1 of Rule 38 reflects that you copy down the note from this book. Page 108 of this book. Only tick portions. So stating, after copying the paragraph, so stating, it is submitted that the petitioner failed to produce a letter to show that the head of his office or the company commander was aware of the intention of the petitioner to appear before the medical authority and the medical authority was supplied by the and the medical authority was informed, not supplied, and the medical authority was properly informed about the intention of the petitioner to apply for resignation. All right.
To apply for the
Invalid resignation or to apply for invalid pension, not resignation. To apply for invalid pension, full stop.
there is no recommendation for the medical authority. We have understood.
It is also contended that there was no recommendation from the medical authority. What?
Not from the medical authority, because what of the authority has to constitute the board. That was not constituted.
Mm.
Lordship, in fact, the certificate which was produced by
Okay.
Nagaland and then that has been placed on record, Lordship. This is just for general certificate.
Okay.
So,
And there has to be a recommendation from the medical authority
Lordship,
after a formally constituted board. After a board is formally constituted for the purpose,
Lord.
for the purpose.
And thereafter, Lordship, based on this office memorandum, Lordship,
Mm.
there has to be a prior approval from the PNR department. And moreover, Lordship, from the office memorandum, it's clearly stated that there has to be a proposed date of retirement.
Yes, I'll note it down. You have stated something more, or it is further submitted that the medical certificate is not a specific certificate certifying or not a specific certificate for the purpose of invalid pension, but the medical certificate marked as annexure.
Annexure to. Page 15, annexure to.
Annexure 2 of the petition is a general medical certificate, which is not consistent to the which is inconsistent with the rules or office memo,
Inconsistent with the rules as well as the.
which is inconsistent with the rules as well as the office memo dated 22nd December 2015. It is also contended that what PNR? PNAR.
Lordship, personal and administrative reforms run department. Lordship, page 7 of the. Procedure 2.
Prior clearance from the PNAR obtained. Is also submitted that no clearance from the PNAR department was obtained by the petitioner before he was released from service on invalid pension, full stop. It is further submitted that what was not mentioned?
Specific for B,
Oh.
more particularly 2B.
Or the proposed date of retirement was also not mentioned. Okay,
And moreover.
not the proposed date of retirement was also not informed
And moreover.
to the authority.
To the authority. And moreover, they have to furnish the service book along with the medical board to come.
This was also not furnished.
No.
Are you sure?
Lordship.
When they will ask for pension, they will furnish the service book.
Lordship, that is.
I know that much.
Lordship, that.
They will forward the service book
Lordship,
for pension.
They are finally provides provisions.
Ah.
And all these submissions are silent on that. And this court has to decide based on the record, which is the purpose of the court.
Lordship, so basing on that, Lordship, what I'm saying before this Lordship is.
No, if somebody seeks pension from the office, they will forward the service book.
Lordship, but here is the case where that has not been.
Then I don't know what type of office they are functioning. I don't know.
Lordship, because of that, Lordship, they are recorded on group of options. And as far as our submission, I have clearly stated now regarding Rule 26. Lordship, since they have tendered a resignation and moreover, Lordship, it amounts to resignation where Lordship may kindly come to page 19, Lordship, page 19 of the.
It is also contended that the service book and
medical board recommendation.
Service book of the petitioner and the medical board's recommendation was also not furnished by the petitioner to the department, to the authority or to the department,
To
the authority.
moreover, page 19, Lordship.
Page 19.
Page 19 of the writ petition.
Page 19 of the writ petition.
Page 19 of the writ petition. Here, the order, while according ascension, page 19. Lordship. Here,
The
the
learned
last-
counsel for the state respondent laid stress in his argument that the order.
Lordship,
Uh,
that in the sanction order, the petitioner is being discharged from service at his own request. Lordship.
that the sanction order dated 3/12/2015 marked as Annexure 5.
Annexure 5 of the writ petition.
Annexure 5 of the writ petition reveals that the petitioner was discharged from service on his request.
Lordship. So that invokes rule 26. Lordship.
This tantamounts to resignation as per rule 26 of the CCS rules.
Lord. That's
Page 19, no?
page 18 is the original order and page 19 is the type.
It is further submitted that his dues have already been paid. Dues like leave encashment and gratuity.
Lord. GPF, final GPF.
And final GPF has already been paid to the petitioner. Full stop. So where is your request for resignation on poor eyesight?
What should of course, there's no the letter on the writ petition, but the letter certificate which was issued by the
Only the
controlling officer-
certificate, yes.
controlling officer.
Uh,
It is made to understand that the petitioner has appointed the authority. And basing on the certificate which was issued by the board, the controlling officer has issued this certificate.
All right. I'll come back to you again. Learned Standing Counsel for the Accountant General has fairly submitted that Rule 26 relates to resignation, and this case falls under Rule 38 of the CCS Rules of 1972. You have given a dictation. You have marked Annexure B somewhere, no? Annexure B somewhere? Anywhere you have marked Annexure B? Yes, no? Where you have marked Annexure B, just include Annexure B of the affidavit in opposition dated 19/8/2026. Okay. The Learned Standing Council has further submitted that the discharge certificate issued by the was discharge certificate dated 15/9/2015, what was issued in an apathetic manner, full stop. The petitioner's grievance ought to have been, the petitioner's grievance, petitioner's medical condition, not grievance, medical condition ought to have been included while issuing the discharge certificate. I have considered the submissions at the bar with circumspection. The learned counsel, learned government advocate has relied on the decision delay and latches.
Delay.
Surjit Singh.
Surjit. Para.
Ashok Kumar Agarwal, you have submitted. Ashok Kumar Agarwal? Okay. Surjit Singh, you have submitted.
No.
Has relied on the decision of the Supreme Court in Surjit Singh Sani versus State of Uttar Pradesh and others, reported in within bracket 2022 bracket close 15 SCC 536, wherein it has been held that it is submitted that the petitioner has approached this court after a delay of more than 6 years, and his case suffers from and the petitioner is guilty of, then this case suffers, you strike off the word and this case suffers from, and the petitioner is guilty of delay and laches, full stop. Not for contract. The learned counsel for the petitioner has drawn the attention of this court to the decision of this court in Lokheswar Das versus Union of India, reported in
2014 with year.
Wherein it has been held that, where is the paragraph?
Paragraph starts from 6, para 6.
Para 6. Para 6 to?
Till the last.
Till the last.
670.
Okay, you go to the writ petition, their paragraph, page 28. Let me see, it will be very difficult for her to type and finish in one day. Tomorrow I am going. Whether this will be required or not, para 6 you are saying, no?
6, 7, and 8.
I'm going to the, can you bring it, copy paste? Okay. From GLT? Okay. You have access to GLT. You can bring it, no? Okay, it's okay. Supreme today. The paragraphs may not be similar, but check it.
The judicial writing, I can provide soft copy of the judgment.
Yes, it will be helpful for her. Para 6. Para 7 also. This is after 28 years.
Yes.
And it has relied on the apex court's decision of Tarsem Singh.
And 8 is about continuing law.
It is mentioned here.
Yes.
Next para 7 also. And you want para 8 also.
Eight.
Okay. Para 8 also. Relying on the decision of this court in next para, after para 6, 7, and 8, relying on the decision of this court in Lokeswar Das Supra, within bracket Supra, it is submitted that Lokeswar Das approached the court after 28 years.
Yes.
And this court, after relying on the decision of the Supreme Court in Union of India versus Tarsem Singh, reported in 2008 within bracket 8 bracket SCC 648, observed that explain the difference of continuing wrong and successive wrong. Okay, continuing wrong and successive wrong, full stop. It is further submitted that an issue of pension is a continuous
Wrong.
Okay. Issue of pension is a continuous wrong, full stop. The learned counsel for the petitioner has also relied on the decision of the Supreme Court in Union of India and another versus Ashok Kumar Agarwal, reported in within bracket 2013 bracket plus 16 SCC 147, wherein it has been held that. Can you supply a soft copy of this also?
Yes. Paragraph 58, 59, and 60.
58, 59, and 60. Even then the judgment is here, you just check it, or if these paragraphs are similar to the, here you will get in the writ petition, page 26, you'll get the our High Court judgment, Lokeswar Das, and then this Union of India you will get here. Is written as petitioner.
This authority is only conflict between 162 and 309.
It's marked with pen, 58, 59, and 60. Reverting back to this case, it is held that the ratio of the decision in Tarsem Singh's case Supra is applicable to this case. Moreover, it is also submitted that Tarsem Singh's case will have to mention the entire case, I think.
This key paragraph is also reproduced here.
It is mentioned, reproduce.
Yes.
Okay,
Yes.
Tarsem Singh's case, Supra, is applicable in this instant case, full stop. Moreover, it is also I have also considered the submission that the petitioner's representation was not considered for, no, this is not a representation. Petitioners, you have earlier filed a representation before the department.
Yes.
It was not considered for how many? Okay, the petitioner's representation was also not considered for 6 years. How many years?
It's 6 years as of today.
6 years has not been considered by the department for 6 years, which also led to the delay as alleged by the respondents. Okay. In the light of the decision of the Honorable Supreme Court in Ashok Kumar Agarwal Supra, it is also held that the executive instructions vide OM dated 22/12/2015 is not is inconsistent with the statute. Is inconsistent with the statutory rules. As per Rule 38, an incumbent can seek invalid pension after 7 years of service, and the present petitioner has already completed more than 7.5 years of service in the department. Full stop.
Rule 38 does not prescribe any length of service.
No, where was it then? 7 years?
7 years have been prescribed in the rule. Rule 49 says 10 years. As well as the OM says 10 years.
Okay, Rule
But-
49,
But
okay.
the decision rendered in Nageshwar's case
Okay, okay.
clearly state that
No,
Rule 49 cannot control Rule 38.
Okay, okay. Where is the case? Oh, Lakeshwar Das's case. Okay.
Paragraph 6.
So it is not in the rule, no?
It is not.
So I was under the impression it is in the rule.
Rule is silent. It is silent on the length of service.
What was the last sentence? You sit down and say. You sit down and read it out. Comma, which is silent. Which is silent. Okay, which is silent relating to the length of service. To the length of service. Qualifying, length of service qualifying, invalid pension.
Yes.
And where is that 49 and
Rule 49 clearly has been mentioned in the office memorandum.
no, that
And in the judgment,
Lakeshwar Das.
Paragraph 6. Paragraph 6. Page 3.
I would also I have also relied on the decision of the court in Lakeshwar Das, wherein it has been held that
Page 28.
Lakeshwar Das Supra, wherein it has been held that
Paragraph 6. On the right side. It starts from the 6th line. That's the extent.
yes, I got it. It has been held that the extent and reach of Rule 38 cannot be controlled by Rule 49 within bracket 2 by reading words into it which are not there in the statute. I have considered the submission of the learned counsel for the petitioner that Rule 28 is for general resignation from service and cannot be read conjointly with Rule 38 of the CCS rules, comma, but has to be read in isolation, full stop. Anything else to be recorded? So this is my decision. So in view of the foregoing decisions, this court deems it appropriate to direct the respondent authorities to consider the representation of the petitioner and consider representation of the petitioner from within 6 months.
Your ladyship, since this case was not on merit, if a direction can be issued to grant invalid pension instead of considering the representation.
Also, this there to dispose of the representation, one because also there is a certain procedure what lordship was trying to point out. There is a certain procedure where the petitioner has to apply. So lordship
Has considered all the judicial pronouncements. Now, a direction can be issued in terms of the judicial pronouncement. Now, a direction to consider representation.
Okay, just a moment. I'll just add one sentence. Before that sentence, you add, in view of the foregoing discussions, it is held that under the facts and circumstances of this case, the claim for invalid pension by the petitioner is admissible in law.
Yes.
That much will be correct?
Yes.
That much will be correct. Thereby, the
Direction may be issued to consider granting of invalid pension.
you can add one more line. It is also before this line, you add one more line. So before this, before the last line I have dictated, you add one more. It is also pertinent to mention at this juncture that the petitioner was discharged from service on 15/9/2015.
Yes.
Whereas the OM was notified on OM office memorandum was
Yes.
notified on 22nd December 2015. Then you had that last line which so this is also one more aspect. Then in view of the foregoing discussions, the respondent authorities are therefore directed to consider the representation of the petitioner within 6 months. 6 months from the date of this order.
Otherwise, my respectful submission is to give a direction.
I have already stated that it is admissible in law.
And they have already taken 6 years to consider my representation.
6 months, okay, then for how many, shall I reduce the term?
Yes,
4 months?
a month,
It
right?
has to, it has to go to the penal department.
4 months, 4 months. 3 months, 3 months.
4 months.
4 months is very odd figure for for a judgment. 3 months, 6 months, 1 year.
This lordship.
This is a legit figure for a judgment.
Department has to.
All right, 4 months from the date of this order. In terms of the above observation,
Your ladyship,
uh,
the representation is before the respondent number 3, that is the Director General. of Police.
in
Has to be just considered.
in terms of the above observation, the respondent number 3 is directed to consider representation of the petitioner within 3 months, 4 months from the date of this order.
Just respond number 4.
Respond number 4. Okay, are you sure?
Yes.
Otherwise, it will
No.
go to a wrong office then.
Yes.
In terms of this above, in terms of the above observation, this application stands disposed of. So I'll tweak this order a little bit here and there.
Okay.
I'll tinker this order a little bit here and there. It will remain same, only the language on maybe I think I have repeated some sentences also that I'll strike off.
Right.
Item number 9.
I think you must go. It's a long order. You send somebody else.
May I please your lordship?
Yes, yes.
Lordship, item number 9.
Hmm.
My lordship, this is an application, my lordship, this is an application under section 528 of the BNSS, read it 227 for quashing of the proceedings, my lordship. Pending before the Honorable Court of Judicial Magistrate First
Just a
Class.
moment, just a moment, just a moment. Ceci, that last item, this paper was left behind by the girl. I think she'll need this book also. Yes, yes.
My lordship, this is a application under section 528 of the BNSS,
Hmm.
read with article 227 for quashing of the proceeding pending before the JMFC First Class.
Item number what? Item number?
Item number 9,
Nine.
my lordship,
I,
9.
I don't think I'll be able to hear today. I've
My
already
lord.
been a long dictation.
Yes, my lordship.
You want to submit something? You want to stay?
Yes, my lord, I'm
Uh,
responding.
There is a stay already operating.
State is, actually, state is this, performer.
I'll just hear him out because you see, he has come from Dimapur twice. So I'll
Yes.
hear him out, yes.
My lord, this is the case which I have filed here in district court. So this case has been dragging since 2018. So my learned friend, they filed this petition that it is limitation bar and it cannot come to before this court. That was the issue. But he overruled, the petitioner overruled that this has been confirmed because of the state forum was not functioned for 3-4 years. So after functioning, that I have already taken the condemnation and that matter was continuing. While we were continuing, the petitioner that agreed that they will settle outside the court. So they proposed for the agreement and he suggested that give us the agreement so that we can settle the issue. And accordingly, we have drafted that in our 22 lakhs, so the reduced to 18 lakhs. And that also in the condition also that 9 lakh to be paid first and the rest will be just yearly. That was the good terms they have come into the agreement. Therefore, I have withdrawn the petition from the contesting of the case. So thereafter, after we have drafted, he never signed, he never communicated again, and he just claiming something that dirty politics, dirty policy. Then finally, after so many trials, they came and saying that this is wow. But now, your Honor, this is the case that is statutory. This is come out from 338 NIA. Because this is the case which to be taken trial with deep consideration of the evidence and the fact of the case. So what my friend, the petition which filed before this court may be in practice because this is the case to go for the trial. That we have to bring all the consideration of the evidences, how they have done this. My lord, this is fit case to dismiss and then they have to contest in the trial court, which is already pending, which is filed in CR.
Okay, you have been granted a stay in this case.
Stay, my lordship, my lordship has to decide whether a complaint petition under NI under 138 can be filed after delay of 6 years, 1 month, 9 days of said dishonored.
My lord, this is
Condemnation was
Delay-
allowed.
No, condonation petition was never filed. Condonation petition was never filed. And my lordship, I have judgment, even I have bought authority which is in the hands of my friend. My lordship, both the council, before filing this petition, my lordship, before the NI, they first approached District Consumer Forum. Thereafter, it got dismissed. Thereafter, they went to State Consumer Forum where I have annexed every document where they have withdrawn the matter. They went to the State Consumer Forum after a delay of 300 days of filing. Thereafter, after the order of the State Consumer Forum, they approached this Honorable Court after a month's delay. And thereafter, they have filed the NI proceeding after a delay of 6 years, 1 month, 9 days. And most importantly, my lordship, all these sets of advocates were approaching this Honorable Court, the Consumer Forum and District Consumer Forum, all were the same sets of advocates. And in the District Consumer Forum, the advocate for the accused has already granted.
Just a moment, I won't be able to take up. I won't be able to pick up. This is a very highly contesting case.
Yes.
Really sorry, I won't be able
My
to
lord,
pick up.
conversation is already done in the 20.
Because my lordship, it needs a detailed hearing also.
This is something to delay, just to make the delay.
So we'll have to dispose it at the stage of admission according to you.
Condemnation is.
Yes, it can, no, my lordship, it is the stage of hearing, I think, my lordship, today. And my lordship, it
Oh,
needs
okay.
deliberate hearing because my lordship, it is with regard to fact sum of dates and authority.
That what is it called, live streaming? You put it off live streaming, you put off the live streaming. Only live streaming is put off.
Oh, my lordship.
My lord. What?
Is it, huh? Live streaming? Can you disconnect the live streaming?
My lordship, I am not able to see my lordship. None of the advocates.
But we can hear you. Can you hear us?
Yes, my lordship, but I cannot see anyone.
Live
Yeah.
streaming is gone.
Yes, my lordship. I can only hear my lordship, but I cannot see anyone from here.
Lordship, this is nothing to be considered about the delaying of this. Because
My lordship, I am for my lordship is if hearing the matter, then my lordship, I am the petitioner,
No,
may
no,
be
no, no,
permitted to
no.
submit.
No, I'm not hearing.
Oh. I'm
Just
not
a-
able to
just
see
wait,
actually.
just wait. Disconnect it. Live streaming.
Yes. My lordship, I can hear your voice, my lordship.
I won't be able to hear it.
My lordship.
Because I will be demitting office in 2 months. I already have 10-13 cases to dispose of. Today I have passed an order for
Yes,
1 hour. I think I have kept on dictating.
Yes, my lordship, I can see it.
I'm really sorry. I'm really sorry. This is a
Then
high
my lordship,
interesting matter. I won't be able to hear it. I'm sorry to bring you from Dimapur today. To call you from Dimapur
it's
today.
dragging, but no time.
Huh?
This is dragging.
I know, but I will hear it and I will then release it before my retirement. What will be the point?
Yeah.
It will be better if next week I will fix it and it will be heard next week.
My lordship, I have outstation matters fixed on the completely next week and then thereafter on 710 also. My lordship, can this matter be fixed on 21 for final disposal in that case?
21 September?
Yes, my lordship, because on 7